I have the perspective that most of my clients have two main goals. Peace of mind, that things can be harmonious in the event of a catastrophe or the end-all be-all. In light of that, I believe that to accomplish those goals, I need to provide each client with a little bit of education and then get them organized. I have a big toolkit of tools specific to my practice to accomplish those goals. But to accomplish the education and organization, we just use some basic things. Today I'm going to talk to you about some of those basic educational components. We're going to talk about the 4 components of estate planning and then this chart I've come up with that I call Estate Planning 101. First, let's go through the 4 components of estate planning. Everybody knows about numbers 1 and 4. Of course, you create a plan and then we pass and wealth transitions to the next. But it's 2 and 3 that really drive the bus in my opinion. So once we create that plan, it might include a will or a trust, we have to then fuel the plan by aligning assets with the plan. The good analogy, of course, is an automobile. If you bought a car, before you could use and drive it around, you'd have to fuel the car, of course. And then after about 5,000 miles or so, you might maintain it by changing the oil and rotating the tires. Similarly, with your estate plan, you have to maintain it. All of us have life-changing circumstances. A very common one for my clients, of course, is moving to Florida. In any case, if we create the plan and fuel the plan and maintain the plan, when we pull it out of the garage, it'll work. The next thing we're going to talk about is my chart I call Estate Planning 101. Basically, this covers the 3 areas that every estate plan needs to touch on. Let's first talk about the first 2. Testamentary documents and death beneficiary designations. This is how our assets get to our intended beneficiaries. And of course, the most important thing on the chart is the green arrow. We have to align those 2 columns in order for them to work together. Otherwise, things might circumvent each other. Testamentary documents. For that, we've got a will and a trust. Let's define them. Simply put, a will is a letter from you to the judge. It says, Your Honor, when I die, I want this person in charge and these people or charities get my stuff. And then we go through the probate process. Yes, the most misperceived thing is that a will avoids probate. If you don't have a will, we look to the statute, but otherwise a will is an instruction for probate. And that probate process involves gathering the assets and filing an inventory with court. We notify beneficiaries, we notify creditors, and then settle up with creditors, do an accounting of money in and out, and then to make distributions. Why do we go through court? Very common question. It's to hold people accountable for what they should do, like any court process. But there is a stigma associated with probate, and rightfully so. It's open to the public. It takes a long time. An average probate in Florida is maybe 8 to 12 months, and then it costs thousands of dollars. One of the main tools that we'll use to avoid such a probate is a trust agreement. A trust is great. It's a contract between yourself as the settlor and yourself as the trustee. And as trustee, you're agreeing to hold assets and manage them for yourself again as the beneficiary. You wear all 3 hats during your lifetime. If you became incapacitated, then your successor trustee would step in and manage them for your benefit. And then upon your passing, make distributions to your beneficiaries. A good example that I like to use, or analogy you might say, is that of buckets. Instead of assets being owned by you, we create a second bucket that is your trust, and we align the assets or move them into that bucket. Instead of the assets being owned by you, they'll be owned by you, trustee of your trust dated August 30th, 2019, by way of example. Another example or analogy I like to use is that of a little red wagon. A lot of people had those when they were kids. Radio Flyer was a common brand. So if you've got your red wagon, your trust, as we'll say, and you pull it behind you in life and, oh, I bought a house, I gotta put it in the trust. I've got my financial accounts, I gotta put them in my trust. And then upon your passing, your successor trustee steps in, picks up the handle, and then has an instruction manual, the trust agreement. Oh, I'm going to pay the final bill for the funeral cremation. I'm going to file the final tax return, and then I'm going to make a charitable distribution. Then I'm going to distribute in 3 equal shares to the kids, or whatever your goals are. That's the trust. Moving on to death beneficiary designations. These are effectively contracts. What's a contract? It's 2 promises. Let's use life insurance as a good example. I promise to pay the premium, and they promise to pay my wife $1 million if I died during the term of the contract. Similarly, annuities are contracts. IRAs and 401ks, those are special assets that the federal government has given a classification where there's tax benefits. But once again, if you've got those, you've definitely filled out a death beneficiary designation form. Joint assets and tenants by the entirety, those are all have rights of survivorship. Tenants by the entirety is a classification for spouses when they own real property. A common example would be Jane Smith and John Smith, who own real property as wife and husband, or vice versa. Finally, we have assets that are payable on death or transfer on death, POD and TOD. This is a contract between you and the financial institution directing where the assets should go upon your passing. These are great ways to organize your estate plan, and similar to a trust, they avoid probate. However, I like to think of those assets as a simple hand tool. It might be a flathead screwdriver and a Phillips head screwdriver, and then of course down here we've got our Allen wrench. Anytime you need to make a change, you have to change each of them and grab a different tool, as opposed to a trust or a will, which are power tools. If we align all of our assets with the power tool, we have multiple bits that we can use to change things out. And when we need to change to our trust, it's a simple 1-page amendment. I'm going to move on now to our 3rd section. Advanced directives are tools that we use to plan for incapacity. For financial or contractual matters, we'll use a durable power of attorney. In that document, we're going to name our agent or attorney-in-fact who can make financial decisions for us. They might sign a deed, sign a check, take over our bill pay. Those are the kind of things that we all are familiar with, but that's the document we'll use. On the healthcare side of things, we have 3 pieces of the pie. Our living will is our consent to be unplugged. We're going to designate a healthcare surrogate to make that decision, or where we might go for rehab after a stroke. And HIPAA is the federal law that restricts doctors from sharing our personal medical information. We sign that release. My pragmatic approach is to put all 3 in one document. Makes it simple for the person who's helping us out. Those are the 4 components in Estate Planning 101. If you have questions, I'll look forward to answering them at our appointment in the future.